The Court of Appeal sitting in Abuja has restored the Speaker of Delta State House of Assembly, Oborevwori Sheriff, as the governorship candidate of the People's Democratic Party for the state in the 2023 general elections. The Appellate Court voided and set aside the judgment of Justice Taiwo of the Federal High Court, which had on July 7th nullified his nomination on grounds of certificate forgery and perjury. But Justice Peter Ige, who led other justices of the Appellate Court in Abuja that delivered a landmark judgment, held that claims against the Speaker are criminal in nature and must be proved beyond reasonable doubt. He also held that David Edevie, who instituted the Federal High Court suit, ought to have approached the court through a writ of summons to enable the resolution of disputes and not by originating summons where only affidavit evidence is required. Joining us now to discuss the appeal court's ruling is Liborous Oshoma, a lawyer. Welcome to the morning show, Liborous.
Thank you. Thank you, Doctor.
Well, I mean, the introduction already covers the ground. It remains for me to just say, what's your take?
Yeah, but before my take, let me condole with my friend and brother here. I've not seen him since the demise of our very own Alhaji Hussaini, Gina Hussaini, then as we used to know him in Warri. My condolence.
Thank you.
But that said, if I tell you I didn't know this was going to happen, I will be lying. I told somebody, last week, I said, well, at the bar conference, I was having a conversation with a colleague, and I said, well, I know that the Court of Appeal in matters like this is always usually very liberal and would take the technical posture in interpreting matters like this, just like it happened in the case of Degi Eremio. Also in the case of Abba, if you remember that, the Makodi, the Court of Appeal always pandered towards this position, and we look for a technical, narrow way out of it. But like I said, like it happened in the case of Degi in Bayelsa, the Court of Appeal also told the same line, that being a case of forgery, that the trial court was indeed wrong in delivering judgment against and for PDP then. But the Supreme Court was of a different view, and it is that same view that the Supreme Court had that I'm going to hold today. And I say that what the court simply said is, oh, you should have come by way of originating writ of summons and not originating summons. And also, if you look at that, this is a forgery matter ought to have been proven beyond reasonable doubt. And then the question you would ask is simple. Pre-election matters are time-bound also, just like election petitions, even though the Constitution did not specify time within which they must be dealt with, but they are time-bound in nature. And this is not the era of the Ngigel kind of election matters where you had to call 300 witnesses just to prove a point that is very clear and visible on the face of a document. The question remains, which the Court of Appeal didn't answer anyway, and I hope that the Supreme Court would answer that question. The fact remains, can you cure a defect in a document you did not issue? The Court of Appeal didn't bother to answer all of this. It's just like you have a certificate, a birth certificate for the ordinary man so that the everyday man on the street will understand my analogy. It's like having a birth certificate. On the face of the birth certificate, your date of birth is stated 12th of June, 1979. And then you go depose to an affidavit to say, no, I wasn't born on the 12th of June. I was born in November 1963. Meanwhile, the hospital that issued that birth certificate is still in operation. The hospital is there, and you're saying, no, I can cure this defect with an affidavit. Rather than, why don't you go to the hospital to say, look, there's a mistake in the birth certificate that was issued to me. So please correct this mistake. If truly you were indeed born in that hospital, the hospital will look at its record and say, oh yes, there was a mistake somewhere, so we correct it. We end this matter. WAEC, as we speak, it is not for, like the Court of Appeal has heard that WAEC and the issuing authority ought to be called. And like I said last week, it is not a case of where you call the issuing authority to come and authenticate a certificate issued. The certificate duly issued to Oborevwori Francis O is valid for all intent and purpose. But the man who is parading that certificate and attempting to use an affidavit to, introduce a name and a date of birth that is alien to that certificate is the question. And so, if you believe that the certificate is yours, all you should have done is go to the West African Examination Council that issued the certificate. That question the Court of Appeal did not answer. Rather, the Court of Appeal went on it, and this is not to, in any way. With all due respect, the judgment of the court is stands the position of the law as the position of the law until set aside. So this is not in any way to sit on appeal over the judgment of the Court of Appeal. But what I am saying is that with all sense of humility, I disagree with that position. Because also, if you look at the provisions of section 84:14, please quickly permit me to read. Notwithstanding the provision of this act or rules of a political party, an aspirant who complains that any of the provision of this act and the guidelines of a political party have not been complied with in the selection or nomination of a candidate or political party for election may apply to the Federal High Court for redress. May apply to the Federal High Court for redress. It is not the document. And then, in the Court of Appeal, blowing hot and cold from the same mouth, said that the candidate ought to have waited for this document, for the document to be submitted to INEC, for INEC to display this document before raising their complaint. Does that stop the fact that this document had been submitted? Does this stop the fact that does this also stop the fact that this is the document that the man is parading as his document? So the Court of Appeal for me went into a conjecture. What if that the document, the party had submitted a different person from this candidate? The fact remained that the party attempted to submit this candidate. So the law did not say that you should wait ad infinitum. The law says you may approach the court for redress. And if the parties had approached the court for redress immediately, then I wonder why you now need to wait until names have been submitted when the cause of action has arisen the moment the elections have been conducted and a candidate declared as a winner.
So in that case, because you said that this was pretty much based off technical posture, looking back at that initial ruling that was given by Justice Taiwo, would you say then that that's a ruling that you were in support of?
Yes, because what Justice Taiwo simply did was to look at the document, because this is a matter the court consistently had resolved. In the case of Abba in Makurdi, in the case of Dege Eremiyo, the court didn't say you ought to have called witnesses. The Supreme Court didn't say you ought to have called witnesses to establish that this document on the face of it. So also the court is not saying that on the face of this document that the discrepancies can be cured. The court has not said that. What the court has simply done is to throw this candidate under the bus for APC to crush if the PDP candidate refused to go upstairs. They simply throw him under the bus for APC to crush because it will still get to that time. So the court had not resolved the issues at all. And like I said, the issue is pretty simple. And it's a valid point of law that can be raised at any time. Can you cure a defect in a document with an affidavit, a document you didn't issue? Can you cure a defect in it with an affidavit? The answer is simply no. So I agree, I completely agree with the judgment of Justice Taiwo. Looking at the face of the document, it is obvious that you cannot cure those defects with an affidavit. Simple.
Okay, so two things. The argument made by Mr. Victor Bonka here yesterday was that the Dege Eremiyo case was different. That's the first argument. You're going to react to that. The second argument also being made and pushed around was the case about the writ of summons.
Okay.
So I want you to expatiate on all of that.
Quickly, please permit me to, if you permit me, please quickly, to read a section of the Abba case to support that Saleh and Abba. The Supreme Court held in that case, we have reiterated that it is our considered view that the court below was wrong to have held that the first respondent ought to have been charged, tried, and convicted. This is because the case of the appellant at the trial court is predicted on section 61(1) of the 1999 Constitution that this document that you submitted is fake. That's one. Then secondly, we have reiterated on several occasions that ours is not only a court of law but public policy. Forgery of certificate for the purpose of election and electoral processes and forgery under criminal law are not the same thing. That was the Supreme Court speaking. They are not the same thing. In one, under criminal law, that's when you now, the Court of Appeal missed these 2 points and muddled the two issues together to say, look, forgery under electoral laws is the same thing as forgery under criminal law, and so merge them together and held that no, you ought to prove beyond reasonable doubt. It is in criminal law that you prove beyond reasonable doubt. But in the election petition, the law states, have you presented a forged certificate? That's all the court is interested in. And the court usually determine this on the face of the document. It is not now to begin to file a writ of summons, call 300 witnesses, while the other person will call 30 witnesses, and then for 6-7 years, we are still on the matter. And that is why the court usually, especially in similar cases like this, decides this on the face of the document. I've cited a Supreme Court authority for you. So, and then in the Degi's case, I wonder what is different in the Degi Eremios case. Because in the Degi Eremios case too, the court did not ask that parties should call witnesses. What they did was to follow the holding of the court in Degi Eremios case to say, well, the court had said all you need to do is to depose to a deed of pool, to pull the names together. That's where the difference is. In this case, it is a date of birth and a name on a document validly issued by West African Examination Council that you were 38 when you sat for this exam, but that the certificate was issued to somebody who was 17 or 18 as at the time he wrote the exam. So, and then apart from the name, in your own affidavit you have Oborevwori, on the face of the certificate you have Oborevwori Francis O. But in your own affidavit is Oborevwori Sheriff Francis Orowedo. So, and in all of this, wouldn't it have been easier, Rufai, doctor, to go to WAEC and say, WAEC, there is a mistake. If truly, that's the simple question. If truly this document is mine, it is not from the other party. You have presented the document claiming that it is yours. And the other party is saying, no, this document is not yours because you were born in 1963. You couldn't have been parading a document for somebody that was born in 1979. And you were not born in June, you were born in November. You now rush to court, deposed to an affidavit, and then you went to do a deed of pool, and then you stamped as speaker, you say you're a public officer. And the trial court said, no, looking at the face of this document, there are a lot of discrepancies. And I cannot reconcile these discrepancies, and I cannot, in all honesty, hold that these discrepancies, for the purpose of standing election, are valid. The Court of Appeal closed its eyes completely to all of these issues and said, no, you should have called witnesses on a matter that is clear on the face of the document. The Court of Appeal said,
which is an electoral matter, not
yes,
criminal.
which is an electoral matter, not a criminal matter. The Court of Appeal said, no, we'll close our eyes to that. Go and prove it in criminal court first.
Okay. I've listened to you very carefully. But the same Court of Appeal said that the matters before the court were matters that are criminal in nature. They said that.
Yeah.
And it was on the basis of that they said, look, the matter should be proved beyond reasonable doubt. Second, yesterday when we had a bunker here, I asked him, I said, look, the litigant, that's David Adevie, he's saying that, look, his lawyers are looking at all options. What possible options do you think are available? Can they go all the way to the Supreme Court? Can another person, who took part in the process within the purview of the Electoral Act also raise, certain objections? Do you think we have seen the end of this matter? He was so confident that all these same arguments that you have brought up about the Court of Appeal not looking at other issues and all that, that all those issues, all those authorities were canvassed. And that he was certain that if the matter were to go to the Supreme Court, nothing will happen. That victory had already been ascertained. And then, as I told him, I said, look, there is still enough time. Section 29.5 says all of this process, pre-election matters must be concluded within 180 days from the time of the filing of the suit. So we probably have not seen the end of this matter. He also argued that people have been saying that the ruling is technical, but that it is not true. That it goes to the material fact that David Adevie had no case. But you have a completely different opinion. So how do you think this is likely to be resolved eventually at the Supreme Court? Although you have already given an indication that the Supreme Court will upturn the ruling of the Appellate Court.
Yes. You see, on the first issue of the court saying is criminal in nature, I have cited the Supreme Court authority and I have told you that. My own is, like I always say, this is a court of public opinion. It is for us to educate the everyday man. And thanks to programs like this, the everyday man, including politicians, now discuss law. Because what happens in court, a lot of them are not privileged to get into, the business of what is happening. It is through platforms like this, they are able to get the fact and what is happening. The court had distinguished clearly that for electoral matters, forgery is different and distinct from the criminal nature. I want us to take note of that. I've cited the authority. And then secondly, I do not know, I am not a party in the matter. I do not know what if parties can sit down and decide to resolve. But as far as these issues are concerned, and from what I have explained, you would also agree with me, because it is not, the court had ruled on issues canvassed before them, which is the court upheld the argument of the appellant, which is Oborevwori this time. Those are the issues that the appellant had raised. The issues that the respondent had raised are the issues that I am raising before you now, that on the face of the court can determine these issues on the face of the document presented and not having to call witnesses based on the decisions of Superior Court. And that's why I said, in most cases, you find that the Court of Appeal had always been liberal and leaned towards technicalities.
I heard that, yeah.
And consistently, the Supreme Court, in the case of Degi Eremiyo, the Supreme Court came down heavily on Justice Ada, and that he ought not to have. And so that's why you're now trying to create a distinction where there is none. In this case, what they simply went to do was, okay, since the Supreme Court has said depose to a deed of pool, so let us depose to a deed of pool. But where it is different is that the deed of pool cannot cure a defective, because you are not, he is not even saying that he was born in 1979. And so he is saying that 1963, that he was born in 1963, the date of birth and the month and the year on the certificate are completely different, and the names on the certificate are completely different. So he's saying, look, please correct this with an affidavit. Can you do that? The answer is no. And that's why I think that the Supreme Court is not going to close his eyes to all of these issues and say, oh no, or allow technicality, because he has consistently, right from the days of Oputa GSC, the Supreme Court has consistently held that judges should not allow technicalities to defeat the end of justice. And so what is the justice of this matter? The justice of the matter is the fact that the simple question is, can you correct a document on the face of the document, a discrepancy on a document that you did not issue. If I'm the one issuing authority, then I can correct that, say that same document. That is why even in agreement, they will tell you that you cannot alter the content of this agreement without the consent of both parties. So you have both parties, WAEC and the supposed person that sat down to write this exam, which is, let's assume, it is Oborevwori, Francis or Sheriff. Is it like Evan and Evans? Ewerem. Evan and Evans. Ewerem. And so now you have Francis, you have Sheriff. Right from day one, everybody has known this man as Sheriff. All of a sudden, a certificate emerges and you say you are Francis, and then you depose on affidavit to bring in Sheriff, and then you depose on affidavit to introduce a new date of birth. And so can a single party who is part of the transaction alter the document by an affidavit? These are issues that you don't need to call witnesses.
So you recommend that David Oborevwori should go all the way to the Supreme Court?
Yes. It will also help.
That's the import.
Yes, I will recommend that David Oborevwori should go all the way to Supreme Court, because it also helps the development of our laws. If the current governor of Bayelsa State did not go to Supreme Court, if he had ended it at the Court of Appeal, we wouldn't have had the benefit of the judgment of the Supreme Court in that matter. So in the same vein, if the case of Abba, if they had ended at the Court of Appeal, the same Supreme Court of Appeal told the same line, they wouldn't have had the benefit of the robust judgment of the Supreme Court. So I also believe, for the development of our legal jurisprudence and for the benefit of all of us also to develop and deepen our electoral practices, the matter should go to Supreme Court, and so we all have the benefit of what the Supreme Court has to say about it. And when the Supreme Court, makes a final pronouncement, then lawyers can now rest on the matter. And then those of us that are election petition matters, handles election petition matters, it will further also help us also.
It's boom time.
Yes, it is. I had wish and pray that politicians would play by the rules, because it is when you refuse to play by the rules that aggrieved parties will go to court. And then it will be boom time for lawyers like you and I.
It's also the resources that always go into this, because these are situations that come up quite often when it comes to forged certificates in cases like this. And I wanted to ask, because this is not the first time he's running for office, so even to our guest yesterday, I said, why haven't these issues then come up before? But do political parties, by law, by the Electoral Act that we've been quoting today, do political parties hold any responsibility whatsoever if candidates that they have put forward are found to have forged certificates?
Yes, they do. You see, the one is the penalties. When you present a forged certificate and the court invalidates your candidacy, then the penalty for you is that office, even if you have won the election by majority vote, you vacate the office. But I think it should go beyond that, because recently INEC is proposing electoral offenses, special courts or special commission for dealing with electoral offenses. And I say, no, you don't need a special commission to deal with electoral offenses. The law already empowers you by virtue of section 145(2) to deal with electoral offenses the same way you employ lawyers to handle election petition matters at the tribunal. So if INEC consistently puts its foot down and not leave issues to let the court decide, then the political parties also will play by the rules. But what you see here is desperation on the side of political parties. A governor is leaving office. He wants to ensure that he puts his stooge there, who will pander to his whims and caprices. But at the end of the day, like we have seen consistently in plethora of cases, the governors, when the godfathers, the godson, when they eventually become governors, they always turn against their godfather. Apart from the case of Lagos, we've seen it in almost every cases in Nigeria, starting from Enugu. Remember the Chimaroke and Sullivan Chime. And at the end of the day, how did it turn out? So these people think that you can be a god forever. Allow the process run seamlessly. And at the end of the day, just like we've seen elections now, before, every election will be challenged. But because INEC had made it so transparent and technologically based, you find out at the end of the day, these elections, once elections are conducted, the parties will say, well, I don't think there's anything to go to court for, because the result will be overwhelming and transparent.
Thank you very much for joining us on the morning show today, Mr. Oshoma.